The Roe v. Wade decision, the Supreme Court ending the constitutional protections for abortion that had been in place for nearly 50 years. Court ruled 5-4 to overturn the landmark decision making abortion legal in 1972.
Leslie Jacobs, a law professor at McGeorge, joins us right now. Good morning and thank you for joining us. Let's just get your instant reaction to what just took place this morning.
Well, it's not surprising. It's in line with the draft opinion that was leaked, and I certainly didn't expect the votes to change. So we've got what we expected. I think we also have to note the contrast between this decision and the gun decision that came down yesterday and the religious liberty decision that came down a few days ago, right? When the court declares that there's a constitutional right, reinterprets the Constitution, it takes away the ability of democratic bodies to make laws. And so, you know, with the gun decision, the court said, there's a right, we're expanding it, California can't have its laws anymore. Here with the abortion right, they're saying, oh no, this is controversial and complicated, and it should go back to the states. We're going to abolish the right. It's a different treatment of different rights.
It isn't often the court invalidates an earlier decision though, right?
Well, here we're talking about a almost 50-year-old decision, and people had called this a super precedent, right? Meaning that it was established initially almost 50 years ago in Roe versus Wade with Republican appointed justices in the majority, 4 of them. And then in 1992, 3 Republican appointed justices, it came before the court. The question was, should the court overrule Roe versus Wade? And, you know, drum roll, but ultimately those 3 justices came together and said, you know, we don't know how we would have voted initially, but we're judges. And this is an eternal constitution, or one that's supposed to be enduring in meaning. And we would look like politicians if we overruled it now. That was 1992. And now we have it here. And the justices who are currently on the court have made a different decision about what their judicial role is.
So what changed then since between now and 1992 that, you know, again, we have a Supreme Court that is primarily made up of conservative judges?
Yes, the identity of the judges have changed.
So as we look ahead, what other things are kind of looming out there that we may also think are landmark decisions that could never be changed, that perhaps could be, given the makeup of the court? I believe, isn't there like a big Harvard case that's coming up regarding affirmative action and college admissions? Isn't that still on the docket coming up?
That's coming up next term. Yes, the court will do away with affirmative action in higher education. That's, again, having to do with the equal protection right. Religious liberty, the court is on a march to expand religious liberty. We saw the one case having to do with tuition payments for parents. And that's going to affect California, it may well affect Sacramento, because if a government like a city gives money to parents to send their kids to choose a school that may be a private one, looks like you have to include religious schools that teach religious doctrine and have prayer in them. And so, we've also got a case coming up with a football coach who wants to pray with his students on the players and other people on the 50-yard line after a game. So we're waiting on that decision. The court's also contracting the right of federal agencies to make rules that limit businesses. And so in particular, we're waiting for one having to do with the Equal Protection Agency and its power to make rules that limit what coal plants do for the purpose of addressing climate change.
Okay.
And we can expect that that will be diminished.
Thank you for breaking this down for us. We really appreciate it.